So the Supreme Court has allowed passive euthanasia. Of course, it was one of the cases in which the court has allowed. But what is the legal position as far as passive euthanasia in India is concerned?
If you recall, the first case on passive euthanasia was the Aruna Shanbaug case, that nurse who had been, lying in coma for a very long period of time. Now, Aruna Shanbaug, the Supreme Court permitted that passive euthanasia to happen. That resulted in a new law being drafted, and the law was the Mental Health Act of 2017. And not many people are not aware of this new act. In this new act, you have a right to give an advance directive. So, for instance, you can say that if there is a situation like this ever for you, you should be allowed to go off peacefully rather than being kept on life support. That is an advance directive that everybody can register under this Mental Health Act. But unfortunately, many people don't know about the advance directive, and hardly any people register with regard to their views as to how they should be taken care of. I'm reminded of a very interesting film in which Kalki and Naseeruddin Shah were acting, and both had relatives who were, Naseeruddin's wife was terminally ill, and Kalki's husband was a young man, had met with an accident, and both had very little chance to survive. Naseeruddin's wife was very old, and he was fighting with the doctors that there is some cure somewhere and wanting to keep her somehow alive, even though he couldn't afford it. And Kalki said that my husband was a tennis player and he would not like to live this life. And she was not in favor of going for an aggressive treatment, which would result in, impairment of his movement, etc. And I remember that there was a dialogue between Kalki and Naseeruddin where they say that, how do you know what he would have wanted? You can't decide what is best for him. Now, that's the kind of situation which is taken care of in this Mental Health Act, where you can decide beforehand of how to be taken care of in such a situation. And if you are able to do that, you will be actually solving the problem for the family, because family is in a huge issue of letting the family member go. There are times when you feel that the chance of recovery is almost nil or very, very low. You still keep somebody on life support for years together, because putting someone on the heart-lung machine can really make your heart and lung continue to function with your brain being completely dead. So if the brain is dead, it should be declared that the person has died. And if there is no chance of your full recovery, you are in a position to make an advance directive and get that advance directive registered, which can be then looked upon by the doctors, and that advance directive then binds the doctors to ensure that whatever method that you have desired for yourself to be the way forward in such kind of situation is actually followed. And that is something which is what is required to be done. But otherwise, in this case, the real issue was that since there was no advance directive, the judiciary has to take a call looking at all the circumstances, the surrounding circumstances, the medical reports, the way the patient has been for so long, and then take a very difficult decision of letting that person exercise the right of passive euthanasia and let him go. So I think this judgment has, I'm sure, made a lot of people aware of these facts, and they should be in a position to make an advance directive at least to save their families and the doctors, medical community from taking a call in such kind of a situation.